Hello, welcome again to the LA River Channel. Um, Today I want to talk about, all these homeless camps people have been living in. Believe me, there ain't a person there in the world that does it of their own free will or ain't got nothing better to do. There are people and there are folks just like you. You know, you have good days, you have bad days. You have the things you own, the things you need. But yeah, the government keeps coming and confiscating their stuff, throwing them in the trash, prevent them from retrieving them. Real Yankee stuff. Anyways, this pertains to a, a camp off the LA River. There's about 20 individuals there who've they've had their rights violated and their property confiscated a number of times by the state of California, the Department of Transportation, also known as Caltrans. And today, you're going to learn something. So just sit back, listen, and learn, and try to understand. Okay? Here it goes. Introduction. Inuit Ciopatis. It's a Latin term, and it means he approves of our undertaking. It's a complaint. It's a federal lawsuit. Some pro per means everybody's doing it for themselves. Nobody's got no attorneys except for the state of California. Anyways, just listen and learn. The state of California has a long history of discrimination based on legal schemes, ordinances, codes, as well as other ways. The fact is that California remained in the Union during the American Civil War. The American Civil War was like 1861 to 1865. You better remember that? Slavery, Union. After the Civil War was passed, laws intended to violate free blacks, Chinese, the ones who built the railroad, and other persons' rights, and the free exercise of those rights under the color of law. They're doing that today. They're still doing that today. They have a history of it. In California, ugly laws were passed. Can you believe that? Ugly laws. Ugly laws were passed in San Francisco about 1867. It was the first in the country to make it illegal for people with unsightly or disgusting disabilities. Can you believe that? In public, Congress had to pass a law, Title 42, Section 1983, to protect civil rights. Anti-Okies. You guys know what an Okie is? It's generally this term for white. It basically means if you call a black person a nigger, not a nigger, not like your homie a nigger, but a nigger. Well, an Okie's the white version of it. Anyways, anti-Okie laws were passed in 1937, and they criminalized poor folks newly arrived to the state of California. Even the residents who live there, for bringing or assisting in bringing them, the extremely poor, into the United States Supreme Court had to overturn the law. That's unconstitutional. Is that a trip? That's not a trip, that's the truth. Knowledge is information. Knowledge is power. Ignorance is bliss. But what's right is right. And what's wrong is wrong. Sundown ordinances were crafted as policies and covenants aimed at the socially undesirable people. Federal action was also required to address the issue with the passage of the Civil Rights Act of 1968. Do you see that? From the Civil War, 1861 to 1865. Civil Rights, 1968. That's how long this has been going on. Don't think it can't happen to you or anybody you know or love, because it can. And the way shit's going, it probably will. The defendants, a statewide agency, continue a legacy of civil wrongs and rights violations. The plaintiffs are the victim of today's tyrannical governmental action. I bring forth this action in proper standing under the Central District Jurisdiction Authority, declare, acting in their own interests, individually, joined together to promote fairness in the application of law and judicial economy. Now, I'm not an attorney. None of these plaintiffs' attorneys. But the real attorneys and the judges, they might know what that means. And it might mean something. It probably does. Omanai productive, excuse me, my Latin's fucked up. And I have a fancy education, many years of experience in legal work. Just an individual. Omnium pro tuae right e solemnite esse acta. And what that basically means, all acts are presumed to have been done right. That means our actions in this complaint here, for these civil rights violations, attest everything's been done by the book. The plaintiffs incorporated by references, paragraphs blank through blank. The plaintiffs are acting individually for themselves and in their own interests, joined together, and for all others similarly situated. Respectfully asked to proceed per propria persona. That's a fancy another Latin word. It means I'm broke. I can't afford an attorney, and I'll be representing myself. Well, we will be representing ourselves. The plaintiffs are informed and believe that the court shall offer no special consideration to the plaintiffs, neither do the plaintiffs seek any or ask for any. The plaintiffs are informed and believe that the defendants will be represented by professional counsel that have been educated in the law, and the fact that some of the attorneys may include trial specialists. It neither dissuades or intimidates the plaintiffs. The Supreme Court has addressed the issue of self-representation and propria persona. The Supreme Court, you know what, all the courts in this country, there's only one that's named by the Constitution. And it's that court right there who said it's a fundamental right to represent yourself. The Supreme Court has addressed the issue of self-representation and propria persona, excuse me if I read it again, with an affirmation allowing for self-determination litigation. The fact is well settled then that cases are not contests of gamemanship with the winner-loser determined by minor errors, nor shall the federal courts allow abuses of petty grievances. You know, in case attorneys try to get too smart for us. See, because in good standing, if we're standing in good standing in front of this court, and they're trying to make a fool out of us, well, being in good standing, they're trying to make a fool out of the court. Let me tell you, this federal court, all these judges are appointed by the president. Every one of them was appointed by a president. Not that that means a whole lot in the final outcome of life. The fact is well settled then. On representing parties with the things not material and fair and proper adjudication under the laws and the Constitution of the United States, the plaintiffs are informed and believe that the court will concern itself with questions of law, substantive and material matters. De mentis non curat lex. The law doesn't concern itself with trifles. Therefore, the plaintiffs respectfully submit curis curae este lexit curae. And that means the practice of the court is the law of the court. Now, I'm not an attorney. But these Latin terms, they're used in law and they're used in medicine. Lex non retiae este volata. The law must not be violated, even by the king. We don't have kings here. We have governors, mayors, city councils, board of supervisors, presidents, dickheads like Trump. But hey, shout out to Trump on the Kim Jong-un shit. But just by the way, you white people, you've been feeling like you're being overlooked or whatever. And you showed your power, you got him elected. But the guy's a fucking disaster. I'm giving you guys a shout out. You guys showed that you still got power. But you're going to throw it all away? Because that's where you're headed if you elect that motherfucker again. Back to business at hand. The plaintiffs are incorporated by reference, paragraphs blank through blank. There are numerous cases consider the question of public necessity. It appears where the danger affects the entire community, or so many people are affected that the public interest is involved, that the interest serves complete justification for the defendants who acts to avert the peril of all. It means you could come and take everything, destroy it, if you're going to save the whole block of your city, wherever you live at, your townhouses, your homes, your wherever. You can do that. It is right. It is legal. Public necessity doctrine is an immunity. But that cannot be in a manner unreasonable. Now, reasonable is a funny word. You find it all through the law. Everything's determined by reasonableness and unreasonable. Under the circumstances, necessity may pertain to property only or to pertain to life and limb. In the exercise of this privilege, the actor must reasonably believe that it is a necessity to avert imminent public disaster. See? You could be wrong. Anybody could be wrong. They could act to do something because they really think so. And in that event, they're covered too. But that's not the case here. It's the exact opposite. The restatements of torts, second section 262, privileges created by public necessity. One is privileged, and that's a fancy word to say one can do some shit to commit an act that would otherwise be trespass, to chattel or conversion, if the actor is reasonably believed that it is necessary for a purpose for avoiding public disaster. The following section further explains is applicable where the intermeddles with the chattels of the possession of another is a reasonable effort to protect the public from a public enemy or to prevent or mitigate effects of conflagration, flood, earthquake, or pestilence, or any other badass shit that, you really don't want to go through. The concept of public necessity pertains to many jurisdictions under the separation of powers, government administration. The plaintiffs question not the authority. We're not questioning the authority. Do they have a right? Can they do it? No. But we're questioning the principle, the intentional act committed. Under the circumstance, consider the fact 4 barriers surround the plaintiffs: flood control, interstate highway, and interstate. There's no schools, there's no houses, there's no apartments. It's public land. It's occupied by the raccoons and the earth wildlife and the people who are living there. The plaintiffs are in an adverse position right now, as of right now. They're living in the Los Angeles Flood Control District and are totally removed from any municipalities surrounding the cities of Linwood, Downey, or Southgate. And with direct personal knowledge, allege that the foregoing immunity and our privilege, the standard required, has not been declared, written or verbal or otherwise. They ain't never once said, hey, you know what, there's going to be a tidal wave coming. Hey, there's going to be thunderbolt lightning. Hey, there's going to be a nuclear war. Get the fuck out of here. We got to get you out of here. And they never said any of that. They said, get the fuck out. Leave your shit because we're trashing it. Excuse my English, but the truth is the truth. The plaintiffs, in totality whatsoever, never witnessed any reasonable reason for the trespass to chattel or conversion, nor have the defendants alleged any disaster or calamity or major disturbance having occurred during the incident dates. The plaintiffs were forced under the threat of actual arrest the following dates. Yeah, you guys don't need to know that. But it was gang times. What do you think about that? Well, we're going to take a break right now because I got some other personal business to do. So I want to thank you. I want you to stay tuned. I don't know much about YouTube and all this uploading shit, as you could obviously tell. So stay tuned. I'll get back with you.